All right, so welcome everyone. We're going to talk today about the Committee of Adjustment and what we feel should be covered and what realtors should understand. We'll definitely have some questions at the end for people to ask, and we look forward to today. Thank you so much. So just a little bit of overview on our backgrounds. As you know, I've been involved in real estate since 2010, but in addition, I do management, condominium management, property management, and consulting. And as I mentioned, I'm on the Committee of Adjustment. Chrstine has been involved in planning for many years, and she's currently at the city of Vaughan, where I work with her as a committee member of the Committee of Adjustment. So, and she's also president of the Ontario Association of Committees of Adjustment. So let's drive right in. So what we're going to do is Chrstine's going to present, and I'll be jumping in as we want to basically focus on what realtors need to know about committees of adjustment and planning with respect to variances. And okay, Chrstine.
Great, thanks, Robert. So on my side, I'm just going to turn off my video. Robert, I think you're going to be going through the slides as I speak. And sure. I just want to thank everyone for having me here today. Okay, great. So I just wanted to design the presentation today to speak to you with respect to things that obviously will be useful in your roles as realtors. So we're going to be focusing today on identifying when a variance is required, understanding the submission process for consents and minor variances and what's required in terms of submission materials, and just to generally give you a better understanding as a real estate agent, how you can help identify costs associated with an application to vary the zoning bylaw by way of minor variance or to create a lot through consent. So as a realtor, understanding what a variance is required is important in responding to questions regarding the potential of a property. So a client may want to demolish and rebuild, or they may want to open a new business in an existing plaza. If a variance is required for either an existing or proposed development, there's no 100% certainty that it will be approved. And it can be a lengthy and costly process depending on the proposal. So responding to these questions does require understanding of how you can determine a variance is required. So on this slide, variances are required when an existing or proposed development does not meet the requirements of a municipal zoning bylaw. So this could relate to setbacks, building height, lot coverage for possibly a residential development, possibly a client wants to purchase a property and rebuild, or they may want to move into a commercial plaza and operate a business. So the bylaw will speak to what uses are permitted. So determining that is important. And there's also a number of parking and technical requirements. Robert, I just want to confirm, you wanted me to speak about the 4 tests, and I just want to confirm what slide that's on. Is that coming up?
Next one. Yep, that's the next one.
Perfect. That's where I had it as well. So we've added this slide because it's important to understand the criteria. So if you've determined a variance is required, under the Planning Act, the committee has to make a decision based on all 4 criteria under the Planning Act being met. And these criteria are obviously very much open to interpretation. I always tell people what I think is minor and what you think is minor could be 2 different things. So the first test is the variance minor. This is not a test that's deemed to be mathematical, and a number of tribunal decisions have clarified that. So even if it's tripling the bylaw amount for even a setback per se, depending on the situation, it could still be considered minor. The second test, is it desirable for the appropriate development or use of the land, building, or structure? This test, obviously very interpretive and very much one that the public really regards. So if you're proposing development, obviously the abutting neighbors may not feel that the development is as desirable. And we'll get into some ways in terms of consulting them when you make an application later on in our presentation. And the last 2 tests, does it maintain the intent and purpose of the zoning bylaw and the official plan? These are 2 policy and regulatory documents within the municipality that if you're deviating so far from what the intent of the bylaw or official plan is, most likely it's not considered minor. And examples of that would possibly be wanting to add, a restaurant use within an office commercial plaza that wasn't fully contemplated for that use when it was originally approved through those documents. So next slide, please. So the next slide, understanding the zoning bylaw. So the first step in determining if a variance is required is understanding the zoning requirements for a property. And that really comes by identifying what zone your property is in so that you can identify the permitted uses and the standards in that site. I'm going to sorry, Robert, I'm just going to go on to the next slide just to show the zone map. So I've included this because this is an excellent tool that most municipalities have on their website to help you determine what zone a property is in. I don't know if you can see at the very top right-hand corner, there's a little search button. So you could literally just punch in the property address and a little arrow is going to pop up and it's going to tell you what zone your property is in. If you're not 100% sure or you don't have access to a municipal zone map, you can always call, and it's a very simple question to ask a municipal representative, what is my property zoned? Next slide, please. Once you have that information, you can really pull some valuable information from municipal zoning bylaws to help find immediate answers to your clients' questions that they may have regarding what they can do with their property. This slide, let's say your property from the zone map, you've confirmed that you're C3 local commercial. So once you have, that's your property zone right there. You can look up into the bylaw what your permitted uses are for that zone. So let's say your client did want to open a restaurant or a fitness studio in this 3C local commercial zone property. You would see by this list, and it's just an example, that it's not a permitted use. So immediately you would know that you would have to go through some process to vary the bylaw, whether it be by minor variance, which we're discussing today, or zoning bylaw amendment, which is outside of the scope of this presentation, but it's for the more major development types. So again, you have your zone requirement. So let's say your zone was determined to be a residential zone. If your client wants to, let's say, build a new home on site and they want to know how big they can build their home, by having the zone classification, you can look up in the zoning bylaw and be able to instantly advise, what you can possibly build in terms of setbacks, coverage, how big the home can be. It even goes as far as telling you here what the lot sizes are. So that can be valuable information to sort of have with you. Next slide, please. The zoning bylaw also provides parking requirements, and these parking requirements tend to be tied to specific uses and gross floor area, as you can see in some of these examples. They are defined typically in a separate section of the bylaw. So if you've confirmed that a use complies, so going back to our example of, let's use an example in this chart. Let's say your client wanted to open a automotive retail store. You would be able to, in that plaza, which was not currently operating, they would need 6 parking spaces per 100 square meters of gross floor area. If a higher requirement is generated based on the use of the proposed GFA, you may require a variance to adjust parking, even if the use itself complies. So if the parking on site, if they only have, let's say, 27 spaces, and you want to put a use in that plaza that's going to require more than that, then you're going to be in a position that you're going to have to go to the Committee of Adjustment for a parking variance. So familiarizing yourself with the zoning bylaws and how they work can certainly help provide a better understanding for the potential their property can have in terms of development. Next slide, please. So we're going to move into the minor variance application process. So you've determined with your client that they do need a minor variance to develop their site. So the next steps is sort of determining costs and timing. So as a first step, you would want to obtain the municipal application form. And obviously most of these forms are online and they do a pretty good job of outlining the submission requirements. So for reference, in this slide, I've included a link to the City of Vaughan's minor variance application form, which does provide a pretty comprehensive list of requirements and possible requirements depending on the location and characteristics of your site. So for minor variance drawings, they are part of the submission requirement. They don't have to be drafted by a professional architect or surveyor. However, it is important to note that variances are precise and there's no room for error when you get to that building permit or permit stage. So depending on the complexity of the application, this may be an added cost that you have to consider in terms of rendering professional services to assist you with that. So under the Planning Act, the owner of the land, building, or structure impacted by the bylaw has a right to make a submission to the Committee of Adjustment, and they can authorize any individual to work on their behalf. So again, depending on the complexity of the application, this might be an opportunity to have to consider costs with hiring a professional planner or an expert to assist with that process. It's not necessary, and again, it just is how comfortable the applicant feels with completing the process on their own. Fees do vary from municipality to municipality, but for large urban areas, I can certainly say that the application process is not cheap. In the city of Vaughan, fees are approximately $3,000 for the initial application, and that applies to the standard putting a deck on the back of a house to putting a new use in a building. So the fee just to vary the bylaw is the same. And this does not take into account review fees that some external agencies such as the TRCA or professional consulting fees that may be necessary based on the submission requirements that are identified. So our next slide goes through in more detail some of the additional costs that could be incurred through your application. This list is not comprehensive, but it does contain some of the most common costs. So the first one I just wanted to note, if your property is within a TRCA regulation limit, that's the Toronto Region and Conservation Authority, you can almost guarantee that permit and review fees are required. The TRCA does have a really helpful interactive map on their website. You would literally just type in, like you do for the zoning map, your address, and it will pull up your property and actually pull up a statement saying you are within a regulation limit or you're just within the TRCA jurisdiction. And if you're in the jurisdiction but not the regulation limit, that's good in terms of requirements. The requirements will not be as onerous. So it's always a good idea to just start with the TRCA. Even if you feel that you're not within the TRCA, you'd be surprised how many properties are within their regulation limit and subject to their policies. So moving on to tree protection, I just wanted to touch briefly on this because it does form a major requirement for some of the applications that applicants are not always aware of. So if you have any trees on your property or on neighboring properties that are 20 centimeters in diameter and within 6 feet of any proposed development, you are most likely going to be required to have to provide an arborist report prepared by a professional arborist. So obviously there's going to be fees associated with that. And if you don't submit it with your application, it can cause delays in processing. The next bullet I'm not going to go into in any detail, but it does provide a comprehensive list that, depending on where your property is located or the type of variance that you're asking for, these studies may be required. And again, they're all required to be produced by a professional working in their respective capacities. And the last point in terms of additional costs that I want to point out is public land dedication. Dedicating land into public ownership can be a requirement of a development application depending on the policies that are applicable. So if your client owns a property that has an environmental feature, or they're along a regional or municipal road that has been designated to be widened, they may have to dedicate land to the municipality or to another public body as part of their process. So these types of applications are permitted when you submit a development application of any kind, and they could impact the amount of land that your client has to develop. Next slide, please. So this slide is just to sort of outline, I know we discussed the TRCA regulation mapping, but these are some tools that you can easily use to sort of get more information on a property to sort of help gauge some of these requirements. I'm just going to sort of highlight on the Google Earth here, because believe it or not, municipalities, we do look at Google Earth to see what's on the ground on a property when we take in an application. So that could be looking for trees. As a requirement of your application, you do have to show us all buildings or structures and setbacks. So you'd be surprised how many times we take in applications and what's on the ground through Google Earth, which obviously may not be up to date, but it does give us a good understanding of what's there. And it does allow us to ask some questions about the differences that we may see in the application form versus what's on site. Next slide, please. So plans, drawings, and reference plans, I think I've already kind of touched on this, but just wanted to know, I think I might have, but just in case I haven't, it is important to understand that if you're not consistent with the information that you provide through the application stage, that it does pose a risk to the client at the permit stage or moving forward, because those variances are precise. Next slide. So this is a sample of the required drawing or plan that you would be required to submit with your application. And on the right is a checklist of all the legal requirements through the Planning Act that you need to show on a drawing if there's a characteristic or a feature that exists. Essentially, your drawings have to tell the story of what you're asking for. So depending on the variances, you also may need additional drawings. So if you were, just for example, wanting to build a home that was higher than what the bylaw allowed, you would also need a set of elevation drawings so staff could review the building height variances that are being applied for. And again, if you're dealing with larger commercial sites, these drawings can obviously get a bit more complex. So that may require professional services to assist. So this chart is a high-level summary of the minor variance approval process from start to finish. So once you've submitted your application, staff are obviously going to review that, and they're going to provide recommendations to the applicant and to the committee. Their role is to act as advisors. They do not render any approvals on an application. So as staff, the best position we can put an applicant in is supporting the proposal when it goes forward to the committee. And we do work with staff, or we do work with the applicant to ensure that that does happen. Once the review is complete, we do send out, it is a statutory requirement under the Planning Act to notify the public of an application to vary a zoning bylaw. And as part of that, a mailing will be sent out to all residents within 60 meters of a property, and the applicant will also have to post a sign on their property. So I just wanted to just talk briefly here about the public participation components. So they are notified. And it is recommended that you speak or the applicant consult with the neighbors regarding their proposal before they come to the Committee of Adjustment. In my experience, many times the public are not even aware of why they're receiving a notice. And then when they get the details, sometimes it can be concerning to them, especially if they're, let's just say they're in an area where drainage has constantly been a problem. And now somebody wants to come in and build a bigger house and with a deck and a cabana. Immediately, they believe that those impacts are going to negatively impact the neighborhood. However, there's obviously protocols put in place to ensure that once that development happens, drainage and grading will be resolved, but that's something they're not aware of. So the public notification does give the applicant an opportunity to speak with residents, and especially those that are most impacted. So definitely the abutting neighbors. If you're in a plaza, speaking with some of the other unit holders regarding the proposal can really help you have a better understanding of what the public participation component is going to be when you get to the Committee of Adjustment hearing. The public does have an opportunity to speak to the committee, and the committee will weigh their objections and comments accordingly. So once the committee does hear the application, they will make a decision, and that decision is subject to a 20-day appeal period from the date that the decision is made. Once that appeal period has expired, the decision then becomes final and binding. Now, final and binding means that the decision of the committee is final. However, there may be conditions imposed that need to be cleared. So it's always a good idea to read the decision fully so you understand what needs to be done before you can obtain formal clearance from the municipality. And just one other note, just going back to the appeal period, in terms of costs and timing to a client, if an application is appealed to the local planning appeal tribunal, at that point, the application is out of a municipality's hands, and it can take anywhere from 6 to 12 months to receive a decision from the tribunal. So that can significantly impact a project. Next slide, please. So before moving on to discuss the consent process, I would just like to quickly go through a few examples to provide you with some better context of the minor variance process. So in this case, the applicant applied for a number of variances to facilitate the construction of a proposed dwelling and cabana. And as part of this process, they did, as you'll see in the next set of slides, submit a full set of architectural drawings to support their application. And as part of this approval process, the committee did recommend some conditions, which you can see on the right-hand side. So by just having a look at these conditions, in this case, they had to have an updated arborist report, they had to submit a lot grading plan, they had to demonstrate low impact development measures, which again, relate back to sort of drainage and grading and water flow on a property. And then they also had to obtain a private tree permit, and they had to install tree protection fencing. So these are obviously, each one of these items is going to add costs and as well as time to a proposal. So understanding those conditions and what conditions the committee may incorporate into your decision can occur before you go to the public hearing. I know in the city of Vaughan, we do provide a staff report, which does outline a comprehensive list of conditions that staff will be recommending. They don't typically change, and they're very technical in nature. So anytime you're going to a committee of adjustment hearing, if you don't have access or you have not seen conditions, I would inquire with municipal staff if there are any conditions that are being recommended, because they will obviously, like I said, impact the cost and timing of a project. So this was the site plan that was submitted in this case. So as you can see, it was pretty detailed and the variances were clearly highlighted. And this obviously helps the committee and the public in understanding the proposal. So we here at the City of Vaughan do try and work with applicants to make sure we have pretty comprehensive and easy to read drawings. So as I was noting earlier, you may need additional drawings. And in this case, the applicant was asking for building height. So he did have to provide an elevation drawing to support his application. So use variances is the next example that I wanted to discuss with you. Adding a new use to a site that is not currently permitted by the zoning bylaw can be a bit more difficult than just applying for a straightforward application to build a new residential dwelling. Whether or not these types of variances will be supported by the municipality is highly dependent on compatibility of the proposed use with the official plan and the zoning bylaw. So just for context, if you're again proposing a use that deviates so significantly than what's currently permitted, it's pretty safe to say that it's not going to be processed by way of minor variance, and you're most likely going to have to go through the zoning bylaw amendment process, which can be much longer and obviously more costly. Uses also have the ability to impact parking requirements, as we saw in the parking chart earlier. If your use triggers additional parking requirements, it's most likely that a professional engineer is going to have to prepare a parking study or a traffic study to support your application. These variances tend to be a little bit more contentious than normal. I say normal, than the more straightforward residential applications, because often it's perceived by other unit holders and neighbors, if you require a parking variance, that you're going to negatively impact the current situation on site. I kind of view, I guess the opinion out there is that less parking is never a good thing, especially in a commercial plaza. So regardless of consultation, be prepared in these instances that neighbors and other unit holders may come out to object to your proposal.
I just wanted to ask, so this is an example of a commercial situation, and what very often also is impacts of, let's say it's a condominium corporation unit and site. So there might be some use limitations also within the condominium documents. So I've dealt with that right now with one of the properties I manage, where a tenant moved in and is operating a business that's not allowed by the condo corporation's declaration. So in a way, it's a dual use requirement to be following not only the bylaw, but also the declaration within the condominium governance structure, so that in that case, the owner had to be advised that his tenant had to either change their business to be compliant or to move out. And in fact, that's what's happening right now. So by the end of the month or early in mid-February, there will be no longer using it for the purpose that they were originally. So these uses are also, in a condo context, also applicable. So just because you get an approval at the committee for a change of use, doesn't mean you're off the hook. You might have to do something similar with the board of directors and getting permission, if it's allowed, with the board of directors. Just keep that in mind. So there's a dual track. Whenever we're dealing with condominiums, there's potentially a dual requirement to get approval from the Committee of Adjustment at the city level, municipality, and then similarly at the condo corporation, the board of directors.
Thanks, Robert. That's a very good point. So just in ending the slide, just going back to this example from the Committee of Adjustment standpoint, this proposal did not generate any additional parking requirements. We don't see a variance for parking here. They just wanted to permit the building supply outlet. So in this case, staff did support the proposal and the committee did agree with recommendations and approved the application. Next slide, please. So the last example that I wanted to share with you today is a variance to permit increased gross floor area within a commercial unit. These variances tend to be rather common. Obviously, owners and tenants want to maximize space. However, when they do, they can also, similar to use variances, create additional parking requirements. So in this example, the increased gross floor area of the mezzanine created an increased parking requirement for the site. So I've highlighted the automotive retail store here just so we can use this and play with it as an example. The applicant, if they were putting in an automotive retail store within a unit in this plaza, they would require 6 spaces for each 100 square meters of gross floor area. And if they built a mezzanine that almost doubled the unit in size, they could technically almost double the parking requirement for their unit. You can't obviously add parking to a site. So when these situations happen, the overall parking requirements for the entire site are increased. In this example, the increased gross floor area would have created a increased parking requirement of 27 spaces, which required the applicant to submit a parking justification report to determine if that increase in parking requirement, the site could still adequately be served. This obviously was an added cost because it is the responsibility of the applicant to determine the suitability of their proposal. So when there is a requirement for a parking justification report, as we're seeing in this example, the onus is on the applicant to provide that. They need to justify their proposal. It's not the municipality. Next slide, please.
Sorry, before we move on, I just wanted to add, so for example, if you're, if some of you, I'm not sure if there's some commercial realtors of ours attending today, but if you're doing a leasing, or you're doing, potentially some renovations of a potential unit for purchase or for leasing, and you see a mezzanine in the unit. So first question is this was this done properly with a building permit? And secondly, is it going to trigger, or was it properly handled with respect to the impact on the parking, as you're seeing with this example? If there's more gross floor area added to the unit, it will very often trigger parking requirements. So the other thing that I want to say is, when you have multiple applications over a period of years, with respect to, let's say there's over times, out of, let's say 30 units, 6 or 7 units have added gross floor area in form of mezzanines. That doesn't mean that, just because they go through the process of approval each time, that the aggregate effect of that increased floor area is not necessarily going to mean that they're all, the last 2 or last 1 is going to be approved. So it's very important to know the history of a site as well, because if you're now if the gross floor area of your unit renovation, the mezzanine increase of space would mean that the difference between what's actually there versus what needs to be there based on the gross floor area is a big difference. And the neighboring properties, as well as potentially neighbors within the plaza, are going to object, because they're all suffering and saying, we don't have enough parking for our customers and our employees. It's going to potentially cause a problem and be potentially difficult to get approved. So it's important to understand not only the individual situation of your, let's say your client, your tenant that you're working with, your landlord, or your purchaser, but also the history of the site, because it could, just because it seems reasonable in isolation, but the history may not deem it reasonable, because there's many approvals that have happened, and the parking is now very stretched, very much varied from the original bylaw.
Yeah, that's a good point, Robert. And just to add to that, again, not all GFA variances will require parking, and not all use variances will require parking. But to Robert's point, when there is a lot of history on the site and the parking's being maxed out through what is existing, that could create some issues with respect to the proposal. Just as a helpful hint, you can always, if you want to do some research on the site, I know you can search applications on the City of Vaughan's website, but just asking for some history from the municipality can sort of give you a good understanding of what was previously approved there. Next slide, please.
Yeah, we're on consent.
Okay, perfect. So this is the second part of the presentation. We're just going to discuss the consent process and when consent is required. For the sake of time today, I'm going to focus on the creation of a new lot. However, I just wanted to point out that a consent is required not only to sever a property, but it's required to deal with any long-term agreement over land, such as an easement or a right-of-way. And in terms of long-term agreement, the Planning Act defines a long-term agreement as any agreement that has the effect of granting the use or right in land for more than 21 years. So for example, if your client wants to enter into an agreement with an abutting property owner for a right-of-way for a period of 19 years, they don't need to go through the consent process. It's once they hit that 21-year mark and higher that they do. Next slide, please. So lot creation can be done one of 2 ways. It can be done either through a plan of subdivision or through consent. So in light of this, an application to create a new lot is generally subject to the same provisions as that of a subdivision, but just on a smaller scale. So depending on how many lots your client is proposing, you may require a plan of subdivision. As a rule, I would say that if someone wants to subdivide a lot into more than 3 parcels, that consultation should be done with the municipality to determine the applicable process. Once you've determined how many lots you want to develop, then you'll need to go back to the zoning bylaw and determine the lot size requirements. So if you remember that chart, it's going to provide you with the lot area. It's going to tell you how big each parcel is going to be, and it's going to tell you how much frontage. And that frontage is the dimension of land that you have abutting the street or the municipal road. If you meet the bylaw requirements for that, it's generally a much smoother process. So you're subdividing land, you need no zoning bylaw relief, and the lots comply. That's a good place to be in. Once you determine, if you determine that a variance to the bylaw is required, then you're going to have to submit minor variance applications concurrently with your consent application to the municipality. And similarly, if your property is located similar, I guess, to a minor variance, if your property is located within an environmentally sensitive area or along a regional or municipal road that's designated to be widened, you may have to convey land again into public ownership as part of the approval. So that really can impact the amount of land that you originally thought you had to work with. So if you do have a parcel of land that you do feel has any environmental features or abutting a major road that's going to be widened, it's good to consult with the municipality in advance. Next slide, please. So this slide, go ahead, Robert.
So I was just going to say that. So for example, in our area, if you're on Bathurst, I'm not saying there's a lot of residential, but there are a lot of commercial properties on, Keele and Jane and Major streets. Those typically, might be a regional road, so you'll have to deal with the city of York, the region of York, for getting, potentially they have requirements as well. So it's not just the city of Vaughan that you're going to have to deal with or get. The file will also need input from the region, especially if there's an impact on their road. So this also impacts any kind of changes to a site, not just obviously we're talking about a consent application, but it's also related to any kind of building or development as well. Go ahead,
That's
Chrstine.
right. Thanks, Rob. Yes, thanks, Robert. So the slide we're on now just outlines some other aspects of the consent process that you may want to consider in terms of understanding the costs associated with this process. One of the most common questions we get from not only the public, but realtors is whether or not a property can be severed. Unfortunately, from a municipal perspective, this is not an easy question for staff to provide an answer for. Given that there's extensive research and policies that are applied to consent applications that need to be reviewed. Generally, as I said before, if you're proposing lots that comply with the bylaw in terms of size and there's no significant environmental features on site, you should have a pretty good chance of going through a relatively smooth process. In the city of Vaughan, we do require a submission of a planning justification report, which has to be prepared by a professional planner with every consent application, even if it's a simple severance to develop one lot, you will still require that. So that obviously will add a cost to the proposal for consent. Another important factor to consider with respect to the process is that for new lot creation, municipalities will require a contribution for parkland or cash in lieu of parkland as a condition of approval. This cash in lieu of parkland is calculated at 5% of the appraised market value of the subject lands, which obviously can be a significant cost added to create the lot. Cash in lieu of parkland is regulated by the Planning Act, and it is a standard condition of approval for any new lot severance. If you want more information or you want to determine what that fee is going to be, you can consult finance staff in a municipality because they're typically responsible for collecting and calculating that amount. And lastly, in order to create your new lot, you're going to require a new legal description for both the severed and retained land. So in order to do that, you're going to have to get a surveyor involved at the end of the process, and they're going to have to provide a reference plan, which is essentially a survey that is deposited at the land registry office. Because a reference plan is always required as a condition of approval, I always advise applicants, especially in situations where they are proposing lots that do not comply with the bylaw, to involve the surveyor up front. The surveyor is going to have to prepare a draft of the plan, and that draft can be submitted with your application and give you some with some certainty that what you're asking for, what's going to be approved, is going to be accurate once it comes down to the final stages. The last thing you want to do is to sort of hand draw a proposal and then get to the end stage where you have to confirm that your lots comply with what you had approved through the committee, and you find out actually your lots are a little bit smaller than what the committee approved. And in that case, you're going back to the committee and reapplying. So that's just sort of my advice when you're dealing with consents. It's going to be a cost that's required. So save some headaches and just get them involved up front in the process. Next slide, please.
Yeah, just before we do that. So again, if your clients are looking at, they see a big lot and some potential for severance, you can sort of understand, get an appreciation of the complexity of the process and the costs involved, as well as the timing. So it's going to take, there's many aspects to this, and we just wanted to try to get better understanding that there is potential. And of course, we're not saying these things don't happen. And of course, they happen all the time. Lots get severed. But again, there is a process to follow. And also the neighbors, we've had many cases where lots have been attempted to be severed. So for example, in the Uplands area, for those are familiar in that area, north of Yonge, south of Highway 7, where the lots are very large on the Vaughan side, very big frontage, 100 foot or more, and the neighbors very much object to severances over there. So there are going to be pockets or areas where it seems to make sense that they meet the bylaw requirements in terms of a severance, but in terms of the response from the neighborhood, there's a lot of opposition, which will play a factor in how the committee responds and potentially approves or not the application. So that is a very important component, as if you're working with an investor who wants to build a house and potentially build a second home and sell that home, that you have to consider not just the technical aspects of the process that we're dealing with today, but also the neighborhood side of it. So we're very often, as committee members, especially when there's opposition, we're asking, have you as the agent, being the consultant, the realtor, the planner, the architect, etc., or the actual applicant, him or herself, gone out to the neighborhood and explained what you're planning, what you're planning to build, and so there's some consultation, so there's less opposition. So we really want to make sure that's very clear as well, that there's that unknown aspect of all these applications related to varying a bylaw that need to have a consultation potentially to make it easier to get approval.
Yes, Robert, and just if I can, and just add to that, again, if you're creating a lot that does comply with the bylaw, then you're not bringing in those 4 tests that we talked about earlier. So as soon as you bring in undersized parcels of land, that's where the committee has to look at that application, and is it deemed minor, is it desirable, and is it generally in keeping with our official plan and zoning. So you bring that element, those 4 criteria, into the consideration of a consent application when lots don't comply, which, like Robert said, the committee does have to also consider those factors. So next slide, please.
Yep. On screen. So
the application process for consents is generally pretty similar, maybe not in terms of requirements, but the flow of the process is similar to the minor variance. There are some exceptions. Obviously, the fees tend to be higher for consents. The city of Vaughan charges almost $3,800 to create one lot. So that's per lot. So if you were dividing a lot into 3, you would require that fee times 2. There tend to be, like Robert said, there's longer processing times for consent applications. The municipality legally has 90 days to make a decision on an application, but that clock doesn't start ticking until your application is complete. So all of those studies and reports that we talked about earlier, they come into play at that time. So until we have all the information, the application, that clock doesn't start ticking. Also, the conditions, and I just wanted to touch upon the conditions of approval, which they can obviously be more significant, but Unlike minor variances, and I didn't speak to this, but minor variances don't typically have a deadline to complete the condition. So if you have a condition on a variance, you're pretty good unless the municipality has said this has to be done within a year or 2 years. For a consent application, you have a statutory 1-year timeframe to complete all conditions. And on the upcoming slides that we're going to see, there's going to be some samples of conditions that sort of show you that how much time they can take to complete. A lot of times I will have applicants coming in the last month or two of the deadline to complete their conditions and scrambling. And because multiple departments and agencies are involved, each with separate processes, it becomes really difficult and sometimes nail biting to get down to the end to see if they will actually satisfy within this statutory time frame. If you don't satisfy with your conditions within the 1 year, the consent lapses and you're essentially starting from scratch. So that obviously can be a significant cost and time to your client, but also very disappointing, I'm sure, when that happens. Next slide, please. So similar, again, to the variance, I'm just trying to compare the two process. The Planning Act regulations dictate what's required in terms of the drawing plan submission, and this slide provides an example of that. If there's existing buildings or structures, so as you can see on this slide, we have the lands to be severed, the lands to be retained, they have a residence that's straddling what's going to be the new property line. In situations like this, the municipality is going to put a condition on that you're going to have to demolish that building, and that's going to have to be done within that 1 year time frame. And that will also come into play for any existing non-complying structures. So if you have any outbuildings or pools, they will all have to be removed because they would not comply with the bylaw once the primary residence is demolished. So the important takeaway from this is if you do want to keep any existing buildings or structures, so let's say, for example, this house was solely contained on this lot, but now it's going to have a much smaller setback, and maybe that setback doesn't comply with the bylaw for the proposed new lot, then you're going to require a variance to be filed concurrently in order for you to be able to keep a structure. Alternatively, you're going to have to demolish them as a condition of approval. Next slide, please. So there's a lot going on in this slide, but it does provide an example of a consent application that we had here at the City of Vaughan to sever a lot in two. So in this case, the proposed severed and the retained lot were both slightly deficient in lot area and frontage. So as you can see on the right side, you have at the top the consent proposal, and then you have a variance for the severed land and you have a variance for the retained land. The costs, just to give you sort of an understanding, the cost to do this application would have been close to $10,000. Obviously, you need the consent, and then you're also going to have to apply for 2 minor variance applications, one for the severed and one for the retained. And again, these are just the initial costs. They don't include the cost of hiring the professional planner that you're going to need to do your justification report, as well as the costs associated with the conditions of approval that we're going to look at on the next slide. So I think I already said this, but the applicant did require the 3 applications in order to facilitate this proposal. And they did propose a new residential dwelling. You can see the outlines on the severed and retained lands. In this case, the proposed dwellings did comply with the bylaw requirements in terms of setbacks and coverage. However, let's say they didn't comply. The applicant could have added additional variances on their 2 applications to support the future development of this site should they have wanted to build bigger homes than what were permitted. Next slide, please. And then, so yes, I think we're getting down to the last slides here. These are the conditions of approval that are typically associated with consent applications. And I'd say these are actually probably pretty common. If you're looking, just to go through them quickly, you're always going to have to, like I said, have a deposit reference plan. So that's where that surveyor is going to get involved. You're possibly going to have legal fees. We will ask for confirmation of a legal description, and the solicitors typically provide that to us in the form of a draft transfer document, and that would apply to the severed land, so the newly created parcel. Common conditions, if there's any outstanding fees or any review fees, I don't see any in this application, but TRCA will typically, if you're within their jurisdiction, require fees. We can see condition number 2 here. They require the demolition of the existing dwelling. Condition number 4 related to that, that's your cash in lieu of parkland. And then engineering typically requires more technical conditions. So that might require the services of a professional engineer to do the site grading and servicing. Another significant cost is you may have to, you will have to pay servicing and related connection fees for the new lot if the connection does not already exist. And then what's most common, taxes always have to be up to date for a property. The municipality will not finalize any approval unless they are. So that's always something to check with your client. And I actually learned something in doing this presentation. Finance always asks for a tree fee here in the city of Vaughan. And I questioned what that was because we have other fees related to the removal of trees. And in this case, the finance department, the city has a policy that the finance department has to take fees to fund new tree plantings across the city, which helps the city develop its tree canopy. So those fees are always included on new lot severances and they're required from the finance department. And here you can see the region did get involved with respect to the regional servicing capacity for the York-Durham sewage system. So that is another condition that's going to have to be addressed. And just to sort of reiterate, you have 1 year to do this. So I always tell applicants, don't forget about it. Sometimes people get this right before summer and they go on holidays and then come back in December and half their time is gone. It's really important to stay on top of these conditions to ensure that you don't lapse the consent, which is extremely costly. Next slide, please. So we'll go through. So I've included some helpful links. We've kind of talked about a few things today in this presentation, but links to the Planning Act, links to the Ontario Association for Committees of Adjustment, which I am president of this year. It's a really interesting organization. And if you ever have any questions about committees of adjustment, I encourage you to look to their website. You can ask questions through their comments. And they do host a number, especially now with COVID going on, we're doing a lot of online webinars. And we do try to reach a diverse group, not only committee members, secretary treasurers, but also the public and getting them to better understand our process. The provincial policy statement, I would say, just to kind of give you a tidbit of sort of helpful advice, the municipal official plans have to incorporate all provincial policy within their official plans. So to save some time and trying to compare multiple documents, the municipal official plans are a good source to go to. But again, the provincial policy statements is good to kind of check for updates. I know in the Ford government, there's obviously been quite a few updates to that. The only other ones I want to point out here, so we've talked about a lot of professional services in our presentation today and the fact that they may be required as part of your application. So there's some really good resources, OPPI, the Ontario Professional Planning Institute, Professional Engineers of Ontario, and I found an International Society of Arboriculture, and they actually are coming out with a directory of arborists. So for those tree inventories, you're going to be able to just look up in a directory to sort of guide you and help find professional services when they're needed. And here is that link for that TRCA online regulatory search tool.
Thank you so much for watching. If you like our video, please hit the like button, the subscribe, and even the little bell to get notifications, just so you can stay in touch and watch more of these great videos.